Joe Whitley, head of the Mackrell International Practice Group, delighted to have you with us, taking us through this session with your Baker Donelson colleagues who you are going to introduce. The floor is yours.
Thank you, Keith. It's a great pleasure to be here with you and from across the pond. I'm sitting in Atlanta, Georgia today, and you're sitting in London. So that's the beauty of the Mackrell programming, is that we can be any place at any time. And I'm really delighted today, as chair of the White Collar Practice Group, to introduce a program on foreign trade risk. And this program, I believe, will be of great value to anyone who has anything to do with any trade that might somehow be connected to the U.S. And I'm delighted to be joined by Michael Clark, Alan Enslen, and Leiva, of my two of whom are my law firm, and I'll make some introductions in a moment. But our agenda today is look at U.S. export control developments impacting the Committee on Foreign Investment in the United States, reviews and technology transfers. CFIUS is what this is known as, Committee on Foreign Investment in the United States. We'll be looking at cybersecurity considerations for CFIUS-related transactions. And these are situations where foreign entities acquire U.S. assets that may be deemed to be sensitive assets. We'll be looking at potentially available foreign statutes for the prosecution and enforcement of trade fraud and related activities, along with recent cases here in the United States. With me today for this program are Michael Clark, who will be running the show with our slides in a moment, Alan Enslen and Leiva. Michael is a colleague of mine at Baker Donelson, and Michael practices in Houston, Texas. He is an accomplished litigator with substantial experience in prosecuting cases here in the United States. For a number of years, he was chief of the criminal division for the U.S. Attorney's Office in Houston. He is a trial lawyer, having tried over 100 cases, and he has great experience in healthcare fraud matters, False Claims Act matters, and any number of criminal enforcement matters. He's highly recognized in the healthcare bar here in the United States. Alan Enslen, who was with us here at Baker Donelson, but has recently joined Womble Bond, led our international trade and national security practice here. He is had been a member of our global business team, and we're delighted to have him with us. He focuses his practice on international trade strategies, government investigations, and regulatory enforcement. He represents clients in international trade and national security matters. Last is Leiva, who will be presenting, and Al is an expert in cybersecurity matters. He represents clients in data breaches, data privacy issues, and complex cybersecurity issues. He served as compliance counsel and cybersecurity risk mitigation counsel, and as general counsel for numerous companies. Al has a resume replete with many other accomplishments, but for purposes of today, I'll make things a little bit shorter. What I wanted to do now is get us right into the meat of our program, Keith, with our first presenter, Michael Clark, to talk through potential federal statutes to prosecute trade fraud in activities, agencies, and recent cases. Michael?
Well, thank you very much, Joe. And Keith, I appreciate the opportunity to present to this group, and we'll try to make it as focused as we can. And in that regard, I have a number of slides, as do my colleagues, and we're not going to engage in death by PowerPoint, but a lot of these resources will be made available to anybody who would like to have them. But I'll try to hit some of the high points and move into some extemporaneous comments. So as soon as I can get the controls working here, we'll do that. Let me see. So our agenda, we're going to be talking about the export control of U.S. Products imported and exported that impact CFIUS reviews and technology transfers. We're going to be talking about cybersecurity considerations for CFIUS regulated transactions. And then we're going to talk about available federal United States statutes to prosecute and enforce trade fraud and related activities, along with some recent cases. We're flipping this agenda, however, and I'm going to move first into these federal statutes. and just lay out that it's kind of a multi-pronged issue here. There are administrative aspects to it, there are civil aspects to it, and then worst case scenarios, these types of activities can morph into criminal investigation and enforcement. And at the end of my presentation, I'm going to just hit on some high-profile matters that kind of give you a flavor of some of the enforcement of these statutes and how far-reaching and dangerous they can be. So we've already heard our introduction, and thank you, Joe, for putting a fine point on that. But it talks about who we are and what we've done. So here are a few of the United States federal agencies and a summary of some of the statutes, and then I'll be covering some recent governmental enforcement actions. The U.S. Department of Justice is the trial arm of the federal government, representing the United States in federal district court. Basically bifurcated. We have what we call main justice of the Department of Justice, and that's located in Washington, D.C. And then the U.S. Department of Justice has a number of U.S. attorneys, Joe having been a former U.S. attorney, throughout the United States federal districts in the nation. We're getting competition with my landline here. I'm sorry about that, but it'll pass. Other major agencies are the U.S. Department of Homeland Security. Joe, you were the first general counsel for this agency that was created after the 9/11 attacks. And it reorganized when this was created, the U.S. Citizen and Immigration Services and other key federal agencies that are involved in protecting our homeland, that being the nation's borders and the security issues for the United States. A small agency within the U.S. Department of Treasury that I had dealings with as a federal prosecutor years ago is what we call Ofac, which is the Office of Foreign Assets Control. Within the Department of Treasury, it administers and enforces the economic and trade sanctions laws of the United States foreign government. We track such things as designated foreign nationals, and it's kind of a critical agency for purposes of transactional matters that reach out between domestic and foreign countries. We have some pretty arcane trade laws, and they keep track of what we consider to be some of the real concerns, like companies that are engaged in transactions with foreign countries that have been designated as dangerous, like Iran, for example, with weapons of mass destruction and proliferation of weapons of mass destruction, threats to our national security, foreign policy, or our economy. We have the Bureau of Industry and Security, which is the department within Commerce that oversees export control activities. Again, it's focused on advancing U.S. national security and foreign policy objectives. Export controls and treaty compliance measures are overseen. The plenary law enforcement agency for the United States is the FBI, the Federal Bureau of Investigation, and it's structured to include intelligence and security services. It includes now a heightened focus on cybersecurity and responding to international cybersecurity threats. Think about ransomware and acts that have been done to shut down major pipelines and things that are breaching our national security, oftentimes allegedly coming from hostile countries. And in that regard, some of the concerns have been about China and Russia and some of the Eastern Bloc countries. So lots of statutes can come to play. I'm not going to go into excruciating details about these, but I'll just tell you that the International Economic Emergency Powers Act is, IEPA in the parlance, is a major statute. The Trading with the Enemy Act is the older piece of this trade law enforcement in the criminal parlance. They allow the federal government to bring criminal charges against foreign nationals and domestic citizens who have engaged in violations of these statutes. And then we have a little bit more arcane and ever-changing statutes, like the Buy American Act, which focuses on making sure that the United States government is protecting major companies, and that we aren't just importing things without protecting our key industries. The Trade Agreements Act of 1979 is another. Then we have the old workhorses in the United States that federal prosecutors have come to love and use all the time: mail fraud, wire fraud, conspiracy, are critical statutes. They're really easy conceptually to use. Mail fraud, essentially, if I am a bad actor and I devise a scheme to defraud and use a instrumentality of the United States, that being the U.S. Postal Services, it is a crime, and it's a felony. Wire fraud is a little bit of an adjunct to that. It looks at a person who creates a scheme to defraud and in implementing that uses the wires, that being telephone, telegraph, emails, you name it. Conspiracy is a easy statute conceptually. Two or more people get together to do something that the law forbids, that being an offense against the United States or against one of the statutes of the United States. More recently, as part of the activities to attack drug trafficking and organized crime, money laundering was enacted. It's becoming very, very well used, and it allows not only to grab funds for forfeiture, but also has criminal provisions, and it's used oftentimes in these types of cases. A part of the Securities Exchange Commission prohibitions is the Foreign Corrupt Practices Act, which is far-reaching. Then we have the Arms Control Act, and the Aggravated Identity Theft Act is now an increasingly important one, where people are engaging in computer hacking and other things, steal identities, and then use that to defraud victims. And on and on and on. Computer fraud, access device fraud, unlawfully obtaining computer systems has a number of statutes. And the Civil False Claims Act is a critical statute in the United States' arsenal, because it allows a government agency that's been defrauded, somebody can sue in the United States in the name of the federal government and receive a substantial bounty. We borrowed this law from the common law. It started in the United Kingdom, and it has now become really the workhorse of the federal government. Oftentimes in procurement fraud, you'll have a False Claims Act issue. aleiva, I'm just going to briefly talk about it because there's a lot of activity in that area. It has empowered the United States president to do all sorts of things, including blocking and investigating, regulating, and nullifying transactions that involve designated foreign nationals of hostile countries. And so, for example, Iran has its limitations on doing business, and oftentimes there's going to be listing of designated foreign nationals that have been deemed to be hostile that are essentially instrumentalities of the government of Iran. There have been traditionally statutes and executive orders that have designated various enemies of the United States or hostile countries, such as Cuba and Iran, and in the past Libya, and so on. And this is what this statute is designed to have: administrative, civil, and even criminal enforcement activities. Just now, I'm going to blow through some of the cases that have come down. In my former office that I was criminal chief of in Houston, that's the Southern District of Texas. Here's an example. In late 2020, the press release indicated that 15 were named in a $26 million international fraud scheme. It included charges in a related civil complaint going after alleged international trade fraud violations from a decade-long scheme involving tires from China and company was called Enslen, and essentially it alleged that there were trade fraud and circumventing the anti-dumping duties associated with Chinese manufacturers who had engaged in unfair trade practice in the United States. Here's another. The United States office in New York, Southern District, had announced the extradition of a global cryptocurrency scheme in late 2020, according to the indictments that were unsealed. The schemers induced investors to invest in cash in a thing called the Airbit Club for promised guaranteed profits in exchange for club memberships in a multi-level marketing club involving the cryptocurrency industry. I happen to know a little bit more about this because I was contacted by one of the alleged defendants in this case to be retained. I couldn't get retained, but I know a little bit more about this case. That case is pending trial up in Manhattan. Here's an example of a foreign corrupt practices and conspiracy to invite implementing regulations of ITAR. Airbus agreed to pay a sizable amount, almost $4 billion, to resolve the foreign bribery and ITAR case in early January of 2020. The allegations that were brought was that Airbus, based in France, which is a consortium in the EU, had agreed to pay more than $3.9 billion to resolve foreign bribery charges. The alleged scheme was using third-party business partners to bribe government officials and non-government airline executives. This violated the Arms Export Control Act and its implementing regulations. We call it ITAR, which is short for the International Traffic in Arms Regulations. This was the largest global foreign bribery resolution in the United States to date as of January 31st of 2020. Moving along, here's another out of the Eastern District of New York. It's another cybersecurity case. A cyber criminal was charged with unauthorized computer intrusion, wire fraud, securities fraud, and other crimes. And interestingly enough, this involved a Lithuanian national who had intruded into US-based computers, including emails, for US financial institutions, stole money, allegedly, from online bank accounts and security brokerage accounts. They obtained login information and stole it using a server of a securities order management company to which the trades had to be processed. Here's an Australian national who was sentenced to prison for exporting electronics to Iran. The defendant admitted shipping aircraft parts to an Iranian front in violation of the US embargo. This was 2019. That individual received 24 months in prison for violating the aleiva. Now, the federal system in the United States is a system that, in the criminal parlance, we have the federal sentencing guidelines, which were created to have truth in sentencing. So anybody who's sentenced under the federal sentencing guidelines has to do real time. Effectively, 85% of the sentence has to be served. So it does have a lot of strength to it. Here's an example out of the District of Massachusetts, Boston, where a California individual pled guilty to illegally exporting cesium atomic clocks to Hong Kong, and these are controlled by the US government for national security and anti-terrorism reasons. This happened in late 2020. Individual named Alex Yun Chong Yu pled guilty, and the allegations are set out in the press release, but he falsely represented that the clocks would be used solely in the United States for codeless foreign research and development. Tax violations are also part of the trade fraud enforcement arsenal. Here's an example. A CEO of a multi-billion-dollar company was charged with decades-long evasion and wire fraud schemes, and it essentially alleged that he had used secret Bermudian bank accounts to conceal about $2 billion in income. He was actually from my fair city, Houston, Texas. And, you know, it alleges that essentially the scheme was fairly elaborate Moving on, other allegations have been made by Joe, your part of the country, the Northern District of Georgia. Chinese military personnel were charged with computer fraud, economic espionage, and wire fraud for hacking into credit reporting entity called Equifax. It's one of our major credit rating agencies. Allegedly, these were members of the Chinese government's 54th Research Institute, part of the Chinese military, that they had conspired to hack into computer networks, kept unauthorized access of those computers, and stole sensitive and personally identifiable information for about 145 million Americans. They were charged with stealing trade secrets, at being Equifax's data compilation, database designs, and that they had tried to evade detection by a fairly elaborate method of routing traffic through about 34 servers in about 20 countries using encrypted communication channels within Equifax's network to try to blend in with normal network activity and deleting files and wiping logs daily. So as you can see, these are very sophisticated schemes that are being alleged here and take a lot of coordination between our federal government and other countries to unravel and to prosecute. Moving on, this one got a lot of attention with what was happening in the United States, charging a very prominent individual with Huawei, a device company. It involved extradition from Canada. The Western District of Washington, Seattle, brought charges against the entity Huawei and corporate entities alleging they conspired to steal trade secret technology, offered bonuses to workers who did so. It is a 10-count indictment that was involved, charging theft of trade secrets, wire fraud, obstruction of justice, and goes on to describe the scheme, including that the allegations are that, according to internal Huawei documents, that the company was offering bonuses to employees who succeeded in stealing confidential information for other companies. Just real quickly, here's an example involving aleiva and the Trading with the Enemy Act. Back in 2015, it's an older one, but I thought it was important because it had to do with Credit Agricole Corporate and Investment Bank, headquartered in Paris, that agreed to forfeit 312 million, entered into a deferred prosecution agreement for violating aleiva and the Trading with the Enemy Act. Basically, this was a fairly prominent prosecution. The entity had to forfeit, essentially pay 787 million in criminal and civil financial penalties. RICO, the Racketeering and Corrupt Organizations Act, is oftentimes used for major allegations. In this potential case here, 15 defendants pled guilty to racketeering. It involved an international cyber fraud scheme. Romanian national pled guilty to RICO conspiracy. Go on into the granular aspects of the case. He managed conspirators throughout the enterprise. It involved obtaining fraudulently Bitcoin, and they had posted false advertisements to popular online auction and sales programs like Craigslist and eBay to buy goods that didn't exist. People would convince Americans to send money, and they would impersonate military members of Romania and other countries, and saying that they had to sell this before they were deployed. And so this is just a flavor of some of the types of violations that we see. There's many more, but in the interest of saving time for my colleagues, I will bring this part of the presentation to a close, and I'm going to turn this over now. I believe, I can't tell, but I believe it's Alan Enslen who's going to talk. Yeah, it's Mr. Enslen who's going to talk about CFIUS. And Alan, I turn it over to you, my friend.
Okay, thank you, Michael. I appreciate that. Yeah, that's what we're going to do, is look at some of the changes to the CFIUS process that have happened over the last few years, and with the understanding that this is predominantly a enforcement and litigation audience. A lot of this is going to sound distinctly transactional, but that is obviously the basis of a CFIUS analysis. And I think what we're going to do is come out of this with some takeaways as to what you would drill down on to try to spot either the weaknesses in a case or the opportunities within a case, that involves a CFIUS analysis. So first of all, with regard to the relevant statutory authority, we'll get big picture and work down from there quickly into the weeds. But the main takeaway is that the National Defense Authorization Act of 2019, so a few years ago, there were two particular statutes that came out of that are key to the CFIUS changes. The first one being ECRA, or the Export Control Reform Act, which, in addition to other things specific to export controls, it also directed the President of the United States to analyze and identify any emerging and foundational technologies, and those are terms of art within the statute, that are essential to U.S. national security, and then to look at the export controls, if any, on those technologies and to make them appropriate. Now that will plug right into a lot of the changes to CFIUS. The more significant, I would say, statute for the CFIUS changes is FIRMA, which is the Foreign Investment Risk Review Modernization Act. And apologies, we're missing an investment on our slide there, but it is indeed FIRMA. That's usually the statute you're going to hear associated with CFIUS reform. And it really, as the slide says, it overhauled the CFIUS regulations. I mean, and in the interest of time, we can't get too far into what CFIUS is, but if you're not familiar with it, think of it as just the main foreign direct investment review mechanism for the US government, and most countries have something similar, really focused on national security. But as we all know, the concept of what is national security is an evolving concept itself, and it seems to be getting broader with every passing month. And so what FIRMA really did was it broadened the CFIUS jurisdiction out of the realm of what had previously been just a focus on control transactions into the realm of including certain non-controlling investments. And if you wanted, the rationale here is that it creates a huge loophole if the foreign direct investment mechanism is focused solely on control. This is tied directly to the concern over the bleed of intellectual property and other trade secrets and things like that, which you can imagine if a foreign investor wanted to invest something less than controlling investment, and thereby essentially take the CFIUS regs off the table, yet they're still getting access to the intellectual property and things such as that. So this was really designed to tighten that up and to take away that, again, whether you want to call it a loophole or just an uncovered ground, that's really what FIRMA was trying to first and foremost address. Next slide, please. And so we'll take a minute to talk about, I mentioned that emerging and foundational technologies are terms of art with regard to anything you're looking at these days in CFIUS. And as what came out of ECRA, the mandate to look at these, and these are, we'll cover why these are key in a minute, but essentially just remember that these are going to become critical technologies under the CFIUS regs. As you'll find as with most of the things that we all do, the CFIUS analysis is rooted in, definitions that are tied to other definitions, which are tied to other definitions. And unfortunately, that's the daisy chain that you have to kind of navigate now to make sense of the new CFIUS standards. But emerging technologies is what you'll continue to hear a lot about in the past couple of years and probably in the next couple of years. But essentially, the mandate to identify these was rolled out in the fall of 2018 with an advance notice of proposed rulemaking that laid out 14 different areas that, and it was a non-exclusive listing, but that was at least a start for the interagency task force chaired by BIS out of the Bureau of Industry and Security out of Commerce to look at these. And again, the idea is, okay, these are areas that we know there are technologies that are emerging And there may or may not be export controls that are appropriate for protecting U.S. national security concerns. So that's an easier said than done process, as we'll explore here a bit. But so BIS took on the main task of leading that effort. It's by no means just constrained to the Commerce Department. It really involves a whole of government effort, and as they look at these. But you can imagine what some of these categories are. It's AI, it's quantum computing, it's robotics, it's hypersonics, it's precision navigation and timing technology, it's different, advanced surveillance technologies, it's things like that could foreseeably, obviously impact U.S. national security, but because of their emerging nature, may not yet have export controls that are appropriate on it. So that's part of the difficulty. And so in terms of what has been done, the first group that was, and we're not going to, the slides are going to be, to Michael's point earlier, there's, in the interest of time, these slides will mainly be for reference, but we'll focus on really three groups of emerging technology designations that have happened. Early on, BIS rolled out some temporary designations under the Export Administration regulations that were focused on geospatial imagery software, and particularly the use of point clouds. And these were put under some temporary export controls that they're still under actually right now, pending what I believe the U.S. government hopes is going to be a multilateral way to address this kind of technology. So that was, one aspect that was done. And again, that was the first one rolled out in January of 2020. Next slide, please. And then in the middle of 2020, BIS issued a rule on three emerging technologies that were in the chem bio arena, we'll just say. And the significant part of this is those are emerging technologies that are under the Wassenaar arrangement. And the point being that as the US government rolls out these controls, as much as possible, they're trying to do it in a multilateral way, or ideally put them under a multilateral regime, such as the Wassenaar arrangement, nuclear suppliers group, or something like that. Because obviously the rub here is that if you over control, you're going to not only hurt U.S. industry and the ability to export, you're also going to potentially undo a lot of the benefits of export control reform that was done through painstaking effort from 2009 until roughly the beginning of 2020. Which was designed to just control what matters and to bring down export controls and not saddle the U.S. defense industrial base with unnecessary controls. So you can see the rub there as, you want to protect national security, but at the same time, you don't want to cripple your defense industrial base either. So every country has that same assessment, but the U.S. is still in the middle of that right now with this process. So, and then in October of 2020, yeah, there you go. There were 6 controls that were rolled out, and the significance of these were previously unexisting controls. So when I mentioned before, there could be emerging technologies that are so cutting edge and so new that there are not existing controls on them. And that's the category that some of these fell into. And, as not surprising, it's a lot of, 3D printing related, and AI and quantum computing and some other surveillance related aspects. So again, the idea here is some things are going to get export controls that haven't existed before, and that's a significant emotional event for a U.S. company, or really any company that hasn't had to deal with those constraints before on what they can do with their product. So you can see the significance there. And in all these things that we're pointing out, obviously there are enforcement and vulnerability concerns with any failing of a company to do any of these things. So I think that's probably the main focus of this audience, as we analyze what would be happening. Next slide, please. And then again, most of the effort right now is going on with emerging technologies. They haven't gotten to foundational technologies yet. The advanced notice of proposal rulemaking did come out in the middle of 2020. And they did not provide a list of what they're going to be looking at, but it's, common sense points to, certain critical manufacturing aspects. You can for sure know that the semiconductor industry is going to be in the middle of this, and probably some advanced, power supply aspects. And you can probably look at the 100-day supply chain review that the Biden administration has done as a pretty good indicator of some of the areas of focus of these foundational technology assessments. Next slide, please. And then, as well, foundational is going to be true to the word. It's going to be some things that may be very low controlled, but typically used in the manufacture of, whether it's weapons of mass destruction or other defense related types of things. And again, this could be a very, expansive basket if you think about it, because, what is national security? Again, a bit of a sliding scale. So that's where foundational technologies are. Next slide, please. And then, so what does this really mean for a CFIUS analysis, and how has that really impacted or changed it? As I mentioned earlier, emerging and foundational technologies are going to be considered one of the 5 subcategories of the also defined term critical technology. And knowing whether or not a company has a critical technology is now very, very important in a CFIUS assessment, because that's one of the main ways you're going to determine if you have a mandatory, filing or not. And, the term mandatory filing used to not even be associated with CFIUS, except in rare cases where the government directed it. But, now CFIUS, as I mentioned earlier, is not just, or in other words, what is considered to be a covered transaction is not just that controlling investment, but is also the non-controlling aspect. And so it could involve, a non-controlling investment into critical technologies, critical infrastructure, or, access to sensitive personal data of U.S. citizens. Those are kind of the 3, categories of which now the CFIUS analysis is focused on. And, that could result in actually a mandatory, filing with CFIUS now, which again, didn't exist before. Previously, historically, the CFIUS analysis was all about trying to determine if you wanted to try to obtain a safe harbor, have the transaction reviewed, get the government to, essentially resolve all, potential national security factors, and then you get a safe harbor, your transaction will not get unwound downstream. Well, now that still exists, but now you have the overlapping area of, the mandatory aspect. And I think probably the major enforcement point is going to be tied to that. If someone misses a mandatory filing, that's going to be, the main focus of enforcement now. So the other thing is that if you're into CFIUS and you've dealt with it before, you probably recognize the term notice, because that's the traditional way that you would present things to CFIUS. Now with this new process, there also exists a declaration, which is also considered and termed a short form filing. Although it doesn't seem very short if your client is having to file it, it's very invasive still, and still subject to a lot of additional questions from CFIUS. But just realize now that it's not just notice, but declaration is now also a term of art in the CFIUS analysis and process. Next slide, please. So again, the mandatory filing, yeah, there you go. The mandatory filing requirement, that really is now the focus of most companies. And the pragmatic issue it creates is that it's now tied to export control status of the technology, software, or commodities that a company has. And so, you have a number of, again, areas that have to be determined whether or not, you're dealing with a business that is what's called a TID US business, which is technology, infrastructure, and data really is what that really points to. Again, those 3 areas of concern now within the CFIUS analysis. And if you have a company that is a TID US business per the regulations, and they are dealing with one or more critical technologies, the test is now, as of the 15th of October of last year, it's would that technology, software, or commodities, would it require an export authorization to, transfer it to your potential foreign investor? Doesn't mean you're trying to transfer it. It's a hypothetical, test that just looks at that aspect. And, there are other conditions and the things that, that would have to be there as well. But that's the meat and potatoes of it. And the reason I go into that is that it's a significant event for U.S. companies having to do this analysis. Really, for any kind of foreign investment now requires at least a cursory CFIUS analysis to determine if you're going to fall within this mandatory area. And the reality is, for companies that have been exporting and that's part of their daily diet, it's not that big of a concern because they already know what they have. But we've run into cases where quite a few startups, in particular, and technology startups doing very high-end things, they may not know that their U.S. export control status yet because they've never had to export. And that doesn't matter to the U.S. government. The test is, again, it is what it is. So that is pragmatically creating a really tall order for a lot of U.S. companies, and therefore it really affects the transaction chain. And so, from an enforcement standpoint, the idea is looking to make sure that in that compressed transaction chain, the mandatory assessment is not being glossed over and definitely not being ignored. Next slide, please. So, as I mentioned, the main biggest development that is really becoming the squeaky wheel is the tie to the export control regulations. And the other aspect of a mandatory is there at the bottom. You'll see the foreign government mandatory declaration. If a foreign government is going to have a substantial interest in a foreign investor that's also obtaining a substantial interest, that will also trigger a mandatory. But that is, frankly, a more straightforward analysis in most cases, and is not as convoluted as the true TID U.S. business critical technology analysis becomes. Next slide. So that's a lot of mumbo jumbo in the weeds, I realize, on the CFIUS assessment and the analysis that goes along with that. But some of the key takeaways, I think, especially for an enforcement audience, would be that there's been a lot of criticism levied primarily at BIS for the slow pace at which the emerging technology controls are being rolled out. And so, in Congress in particular is levying a lot of that criticism. I will say that to BIS's defense, from the outside, it does look that they're trying to get it right, and they're trying to not over control and cripple industries, at critical times. So, but it's a tough thing. But that you need to understand that there is a lot of controversy over the pace at which emerging and foundational technologies are being designated, because again, you can't fully solve the equation of what is a critical technology because it hasn't all been determined yet. So that's the pragmatic issue. We're going to see over the next couple of years, we're going to continue to see more technology designations rolled out. So as those come out, they'll affect certain industries. And again, you can, if you want to take a risk assessment, you will look at that original 14 categories for emerging technologies that was designated back in the fall of 18 to try to determine, what is likely to be in the firing line. And again, if nothing else, just understand the CFIUS ties to export controls are it's inextricably linked at this point. And so you have to understand both to be able to do that CFIUS analysis. There is quite a bit just within the investment world and in the deal world, I will say, there's a lot of consternation about the utility of these so-called short form declarations, because as it stands, last numbers I've seen, still roughly half of the declarations that are filed result in, at the end of the 30-day review period, CFIUS telling the parties to file a notice. And in other words, then the parties are like, well, we wish we'd have done that to begin with. But so that's part of the risk assessment that now has to be done. In some cases, parties are just going ahead and filing a notice instead of the declaration. And then the other pragmatic point is still roughly 50% of the notices go to an additional 45-day review period of an investigation. So the takeaway there is, it's particularly pertinent to transactional lawyers, is that the CFIUS, the cycle that you need to count on, or that you need to, factor into the time schedule for closing, can expand on you beyond your control based on CFIUS's determinations and actions. And then obviously this is going to have significant impact on the supply chains global supply chains, particularly those that touch any of our economic or political rivals, such as China, Russia. It's not exclusive to those, but those are obviously going to create additional challenges for that consideration. So with that, I will wrap it up and turn it over to my colleague, Leiva.
Thank you, Alan. I appreciate it. And Al, take it away and hit the high points. I'm afraid we are getting short on time, and I know you can do it.
Thanks, Michael, and thanks, Alan, for your presentations. So just to try to wrap this all up here and just focus on the cybersecurity aspects of this, as if it wasn't obvious before, it definitely should be obvious by the close of the presentation. This is a highly complex area of the law. It's going to require a lot of collaboration and participation by many different team members here. So as you can see just from Alan's presentation, you're not just dealing with the deal makers, with the folks who are focusing on the corporate transactions, et cetera. There's a huge regulatory aspect of it. There's going to be a huge technology analysis of this that's going to be required well before you concretize and finalize the deal. So there's a lot of moving parts to this, and there's also a lot of potential of saving a lot of unnecessary headaches and a lot of unnecessary costs if the proper team members are engaged in the beginning. And so with that, I'd like to focus now, and let's go on to the next slide, because I think that Alan covered these as well. So really, we're going to the area of just the next slide. Thank you. So we have before us a situation where, regardless of all the different types of areas and technology development areas and innovative areas that Alan discussed, they all have one thing in common. They all rely on a common infrastructure, especially in the time of COVID, especially in a time when a lot of businesses have had to really double down their investment and on their infrastructure. And by infrastructure, it's basically these kinds of scenarios where you have of computers and network servers, et cetera, all communicating with outside vendors, with outside team members, and basically managing data, especially on these foreign deals, cross-border transactions. So not only do you have the data privacy and the data security implications of that, now through the CFIUS lens, you need to also analyze that as well. So regardless of what potential critical infrastructure sector the participants in the deal may be, they'll all have one thing in common. They will be relying on computers, they will be relying on communications across borders, and they will basically have to then make sure that just from an operations perspective, that their systems will be up to the task of dealing with ransomware attacks, hacking events, insider threat, et cetera. So all this needs to play itself in. So some of the types of critical infrastructure that could be involved here as far as the CFIUS analysis will be communications, obviously internet service providers, submarine cable systems, satellite systems, especially those that are providing services to DoD contractors and the DoD. Manufacturing of critical resources, so specialty metals, chemical weapons, antidotes, et cetera. Obviously energy, electrical energy, oil refineries, and pipelines. I'll take you back to a few months ago when we had that marked increase in fuel costs on the East Coast due to a ransomware attack on the Colonial Pipeline. And again, this was something that had been foreseen in many different industries, and now we're seeing, sadly, a lot of these nightmare scenarios playing out. We see that these types of attacks can wipe out not just information, but may also threaten the operational technology of these systems, i.e. we're talking that, for example, a disastrous attack would be one where you are interfering with the parameters on valves and critical readings and pressure readings and things like that. A hacker can basically seize control of that and modify it. We've had also recent attacks on water supply systems where the chemicals that are being used for critical water supplies are being modified and interfered with, and basically creating poisonous water. So these are very real terrorist attacks that we need to be aware of, but more importantly, this analysis needs to be conducted all the more within the context of a potential CFIUS deal. Next slide. So the Critical Infrastructure and Cybersecurity Agency, CISA, that is the entity that's really responsible for strengthening the security and resilience of cyberspace. And this will include any type of privately owned industry in the United States that's going to be managing critical sector services. And again, to the extent that you're going to have a foreign participant or foreign investor in your business, that's going to come under increasing scrutiny, given that we also have another complicating factor: state actors that are involved in funding and supporting a lot of criminal enterprises out there. So this is more than ever. This is no longer just a science fiction, this could happen. It is happening, and it's something that right now, especially currently, in light of all these events, and in light of what the Biden administration just issued days ago, as far as more reporting requirements from critical infrastructure sector members, this is something that is becoming highly a top priority for the federal government at any level. So next slide. So what are type of risks? You just need to look at any news media that you want to look at now. Unauthorized access or extraction of critical information, basically stealing information, payment information, customer information, disrupting your operations. That can be as simple as what occurred with the city of Atlanta some time ago, where they had fell prey to ransomware incident, and they couldn't process checks. No one could get paid. Vendors couldn't get paid. Employees couldn't get paid. So it was this, and something as simple as that resulted in a lot of problems where the city just couldn't even do business for some time there. Disruption of remote access, that is people who are working at home, as I am at the moment, are unable to access their systems because of this interference by foreign actors or cybersecurity hackers, etc. Modification or deletion of key applications information, that is, they gain access to code and they play around with it, they modify it. Again, another real world example, sadly, was the increasing use of periodic software updates that are being distributed, like the SolarWinds event that occurred, where you had a legitimate software that's used by both government and private entities, and then they were able to smuggle in software into the update that basically resulted in extraction of information. Information technology risks, as I mentioned, just accessing information, but more increasingly the OT, the operational technology risks, which are basically modifying real world controls on real world objects. Next slide. Alan covered much of this, but I really want to focus just on the aspects of a cybersecurity plan. As part of the interdisciplinary analysis that's going to be required here, is that the government will require, as far as notices, a description and a copy of the cybersecurity plan that will be used to protect against cyber attacks on the operation, design, and development of the U.S. businesses, services, networks, systems, data storage, and facilities. So again, this presumes that a cybersecurity plan is in place, that more importantly than that, it has been tested and vetted and updated to react to the ever-evolving threat environment. So again, a plan is essential. So don't even bother going into a deal if you don't have a plan. And that would also apply to whatever foreign entity that your networks may be communicating with. So everyone's cybersecurity plan should be thoroughly vetted, assessed, and updated as necessary, especially to the extent that it needs to be revised in order to facilitate the merger, right, of the two companies. Next slide. So common question is a cybersecurity plan alone sufficient? Obviously, you have to go by whatever standards and whatever measures are being included within that. So, so what can you do? Well, the federal government relies on standards from NIST, National Institute of Standards and Technology. That's commonly used by federal agencies, and that's commonly in turn used by private entities to demonstrate that they are following those standards. Now, keep this in mind. The federal government repeatedly is emphasizing that your mere compliance with NIST does not guarantee that you are compliant with anything. In other words, you need to adapt your plan to the actual threat environment in which you are in. So obviously, for example, a financial services entity will be facing different risks than an entity that doesn't really deal so much with financial information, but more exact. For example, a satellite communications one. So again, you need to adapt your plan to deal with the kind of threats that are going to be specific to that. Also, do you need to demonstrate audits, right? That goes to the plan. After you've submitted either a voluntary or a mandatory filing, you need to basically update and make sure that your plan is keeping a pace of the threats. And again, as I said before, CFIUS states right now that adherence by a party to government or industry standards could be a relevant factor in the committee's risk assessment, but it is not necessary to prescribe and regulate. In other words, they're saying that it could be a relevant factor. They're not going to get into details of telling you which one you should follow. But again, it's a good place to start, but you're going to need to make sure that you have a plan that accurately reflects the risks to your specific sector and your specific business relationship. Next slide. So again, what's the kind of due diligence that should be taken up at that early stage? Obviously, as I said before, taking a look at the cybersecurity plans for both the acquirer and the target networks, make sure that you know what the vulnerabilities are, address them or mitigate them, make sure that you've got the proper policies, procedures, and technologies in place to address them as well. Have your independent audits of plans. Obviously, you don't want to rely on the folks who designed it and made it. You want to get an objective third-party analysis as to how good your system is. 3, risk assessments of the networks. That is, conduct a full risk assessment, find out exactly what your risks are and what your methodologies have been to control and mitigate any types of risks. After the closing, assuming you've been approved and you're sailing along, make sure that the IT infrastructure is being maintained, updated, and dealing with security and connectivity issues, and maintain an inventory, because obviously that critical infrastructure, the computer infrastructure, is going to be evolving with every software update and with every hardware update. So again, this is a moving target that requires a lot of follow-up and constant attention. Lastly, especially if your business has direct U.S. government connections, i.e., you're a government contractor, definitely that's going to be something that's going to be heavily scrutinized and analyzed. So again, just make sure that proper inventories are being taken there. And with that, I think we've concluded my portion of the presentation today. I see that there's a question that came in, but I think that can go to Alan or anyone else on the panel. Thank you.
I just want to say my mind is boggled, and that's a really good thing. Gentlemen, thank you very much, because I know that in some ways you've skimmed the topic, and yet you've gone into at the same time you've gone into a huge amount of depth and really illustrated the complexities and the changing landscape that is, I suppose, that attorneys are facing, and businesses and government in terms of white collar crime. So my thank you to all of you, and to Joe for setting this up. One thing that strikes me is the sophistication of criminals is clearly increasing, and the access, because of improvements in technology, I suppose, makes them more able to evade detection, sort of get around systems. But at the end of the day, are you seeing the same old when it comes to white collar criminals, the motivations are the same, and it's just the sophistication and the technology that is changing? Or are you seeing a real changing landscape which everybody from federal government to local government to business is having to adapt to? And I don't know which one of you gentlemen wants to take that question.
Well, I'm happy to start from the cyber perspective. The reality is that these are age-old fraud techniques. The way you do it is by fooling an internal user. The urgent email saying I need you to issue payment to this address, or we need to update your passwords, a critical update, I need to get your credentials. They can be as clumsy as that, but they can be as sophisticated as infiltrating a third-party legitimate software vendor, as was done in the SolarWinds case, and injecting software into that, and then gaining access to all these government systems and industry systems. So it's a combination of good old-fashioned social engineering methods, where they try to go after employees or people, the person who may be covering a desk that morning maybe didn't get their trainings. That's why training remains a key thing here. If you don't click on it, if you don't download it, then you've closed another door. But then you also have to make sure that your systems are up to snuff. You need to make sure that any kind of updates that are being provided by the government, as far as new threats, critical software updates that are announced, every company needs to make sure that it's updating those, at the right time, because obviously the bad guys are also monitoring those critical updates. If they didn't know about it, they know about it now, so they try to get in there before those get patched up. But that's my perspective. I'd say that we're going to continue to see a pattern of going after human capital, right? Individuals who work for companies or third-party independent contractors, and try to use those relationships to gain access to systems, as opposed to brute force attacks where they're just going to try to infiltrate a system. But those two will continue to occur.
One of the things, if I could, Keith, that
Please.
clearly should be evident is that more is expected now of corporate governance mechanisms, and cybersecurity is a critical piece of it. In the United States, Delaware is a state that has developed specialized courts for dealing with corporate governance issues. And what we're seeing is a heightened responsibility being placed on the officers and directors in particular, that can't necessarily just say that, we had processes in place. They have got to stay on top of their game, or at some point they're going to be subjected to personal liability under what's known as the Caremark doctrine, a case called Caremark that resonated and frightened a lot of boards of directors. So the way of doing business has changed dramatically for obvious reasons. I see that there's got to be a whole lot more coordination between law firms in this country and other countries because of the transnational nature of business, and staying aware of some of these trends is critical. So we appreciate the opportunity to present, and obviously, we have our interest is in partnering up with law firms and colleagues that may have needs of this nature.
And I suppose that's the classic cross-jurisdictional issue is, and the beauty of the Mackrell International Network is having that expertise jurisdiction to jurisdiction, because what happens in one is very different. The requirements in one are very, very different. And I mean, that happens state to state, although as I understand it, white collar crime is federal rather than state-based, or is that not exactly right?
Michael?
I'm seeing a nod.
Yeah.
But coming back to the point, we're talking about the increase in regulation, but it's not yet mandatory for and sort of increase in corporate governance as well, but it's not yet mandatory for every employee contract to have sort of sections relating to how they handle data and cybersecurity, and that training isn't mandatory yet in US companies, is it?
I've seen, actually, depending on the job description, right? So especially in heavily regulated industries, that is being included as far as standard confidentiality requirements. What used to be standard, hey, don't share our internal information, now has been expanded to you employee have a legitimate, have a duty, an expected duty as far as protecting your password, protecting your account, immediately reporting any kind of technical issue that could indicate some kind of vulnerability. So at least from my end, I've seen more attention being played to that, with companies that are at that level of risk, that actually are smart enough to anticipate what the potential risks could be. But I've been seeing more of that out there. I don't know if that's true for the other folks on the panel.
One of the things that I've been watching, and I've spoken about cybersecurity and litigation risks for years, but we have been waiting to see at what point a major regulatory body like the SEC in the United States mandates specific controls, kind of like what they did with the Foreign Corrupt Practices Act with books and records. Once there comes a clear duty that mandates certain minimal behavior as to cybersecurity that is breached, that's going to effectively open the floodgates for civil litigants and class actions to be brought for the breach of that duty. And it's been incremental. The SEC has gotten progressively harsher in what they're expecting, and other agencies with their FARs and DARs, the Federal Acquisition Regulations, so on, that class action plaintiffs counsel will be moving in, and oftentimes, it's parasitic when there's an enforcement action. Then the next wave will be that clearly the corporate governance piece is critical, and if there's a failure by officers and directors to adhere to known duties and standards, then the plaintiffs' lawyers will have a much better time overcoming that initial threshold that they've had trouble with in these class actions, showing a demonstrable duty was breached. So I think we're getting close to that point, and I suspect that the floodgates are filling up pretty fully now, and it's going to be a major issue for companies that do business in our country using our registered exchanges. Even non-domestic companies that have used our securities laws are going to be having to be very careful about this. And I know, Pam, you had asked the question about what's the major focus of CFIUS and what's trying to be controlled here. I think there's a protection aspect of it in the United States, trying to protect our nation's companies. But Alan and Al, you could probably address that question a little bit more. What is the major focus, as you see it, of CFIUS from the domestic policy standpoint?
Well, I will say right now that CFIUS has gone out of its way to really empower the enforcement of non-notified transactions, and quite a bit of the enforcement effort is going into that. And so that really opens up two different cans of worms, if you will. For one, it's really necessary to make sure that everybody understands that you have to get that mandatory declaration assessment correct, because if you don't, then it could result in a a non-notified transaction that should have been notified. So that's we're watching sort of message being brought there, but then it also opens up the more traditional transactions that may not have been considered national security relevant 3 or 4 years ago, that certainly now, because of many of these things, particularly in the cyber realm that we're talking about, suddenly they are. And with the evolving definition of what is national security. And so in those cases, you're finding some companies that are now having to justify to CFIUS why they didn't do something that was voluntary to begin with, which is kind of a difficult place to be in. But that's the reality of what a lot of the enforcement effort that I'm seeing is.
Yeah, and to Alan's point, I mean, just a year ago, the supply chain reality of, for example, who would have thought that ventilators would be so desperately needed, right? And that we needed them in a hurry. That exposed a huge issue we had in even trying for hospitals and healthcare providers to get their hands on those devices, which even you had the Defense Production Act being talked about, et cetera. So it's a moving target. National security can definitely priorities can definitely modify over time, but again, it's going to be something that that just invites more and more assessment and attention to it as time goes by.
Gentlemen, I sense there are more questions. I think we could, and we've gone way over time, but it was absolutely worth it because we've covered a huge amount of ground in some detail. The expertise on show this evening has been outstanding, to be expected, but it's been great to have the three of you. I'm going to hand the last word over to Joe with, again, thanks from me on behalf of Mackrell International. This has been fascinating, and we will definitely publish this wide and loud. So thank you, gents.
Just a final word, Keith, and a word of thanks to you and Pam for helping us put this on today. I think this program encapsulates so much. It's the distillation of many years of experience by my three partners and colleagues. Really delighted to have Alan Enslen with us, who's now at Womble Bond Law Firm, Michael Clark and Leiva with me, who are at Baker Donelson. What we show you here today is collegiality, which is the sort of the centerpiece of Mackrell, which is how do we bridge the gap between not only our lawyers in our law firm, but lawyers with other law firms to provide our clients with superlative legal service across the borders of our countries, across the seas. And this exciting thing about Mackrell is it sets us apart. So all of us who've been here today, Keith, are just really indebted to you and Pam for helping us put this on, because you're helping us get the message out. So I'm hopeful that those of you that are watching this on YouTube or otherwise will pick up the phone and reach out to some of us on this call, or in the alternative, email us, communicate with us. We would welcome it to follow up with you if you have questions or other issues you'd like to address. We believe that the best way to get at these issues is to have the conversation before we have to deal with the hard issues of a case-by-case analysis. So welcome the call now before a crisis. We'd also welcome the call if need be during a crisis. So Keith, with that, I turn it back over to you, and I think a later evening in England right now, but for us, we still have many hours to go before we sleep here. So thanks so much to you and Pam. Take care.
Thank you all. Stay well, stay safe in every sense of the word, and I look forward to seeing you in person at some point in the future. But really appreciate your time, gentlemen, and your insight. Thanks.
Thank you.
Good night.
Thank you.